my name is Rachita Mathur, currently working as a legal intern at LEXIS. So today I'll be discussing on a topic bailment. So a bailment is a special contract that has been defined under section 148 of Indian Contract Act 1872. The word bailment is being derived from the French word that is bailer, which means to deliver. Further, the bailment means a delivery of goods from one person to another for a specific purpose or for a special purpose. Further, it has been stated that the person to whom the goods are being given is known as the bailee, and the person who delivered those goods is known as the bailer. So, while looking at the essential ingredients of the term bailment, there shall be a contract between the parties for the delivery of goods. The goods shall be delivered for a specific purpose only. Further, the bailment can only be done for movable goods and not for immovable goods or money. Further, there shall be a transfer of possession of goods and not the ownership is not being transferred to bailee. Therefore, the bailer remains the owner. The last is the bailee is the duty bound to deliver the same goods back and not any other goods. Now there are some exceptions that the money deposited in the bank shall not account to bailment, as the money returned by the bank would be the same identical note, and it is one of the essentials of the bailment that the same goods are to be delivered back. Now further, while looking at the duties, the first we will be discussing with the duties of bailer that has been provided under section 150 of Indian Contract Act 1872. The first duty is the gratuitous bailment. Now it is the duty of the bailer to disclose all the defect in the goods that he is aware of, and the bailee that can interfere with the use of the goods or can expose him to the extraordinary risk, and the failure to do the same will make the bailer held liable for the damages. In case of non-gratuitous bailment, that is for the bailment or for reward, this duty particular deals with the goods given on hire. As per this provision, when the goods are being bailed for hire, then in such a situation, even if the bailer is unaware of the defect in the goods or not, will be held liable for the injury that has been caused due to the existence of such defect. Further, there was one case of Hyman versus Nye and Son. In this case, the court held that even though the defendant was aware of such defect or not, he shall be held liable. Further, while looking at the duties of bailee, first duty is that the bailee has to take some reasonable care. Now it is the duty of the bailee to take the care of the good as his own goods. He shall ensure all the safety measures that are necessary to protect the goods. The standard of care shall be such taken care by a prudent man. Further, the goods shall be taken care of equally whether they are gratuitous or non-gratuitous. The bailee shall be held liable for the payment of compensation if he fails to take due care, but if the bailee has taken due care and instead of that the goods are being damaged, then in such a situation bailee will not be held liable to pay the compensation. Further, the bailee is not be held liable for any loss of goods due to the destruction by fire. It is provided under section 151 to 152. Further, while looking at the next duty, that is not to make unauthorized use of the goods, the bailee is duty bound to use the goods for a specific purpose only and not otherwise. If he uses the goods for any other purpose other than what is agreed for, then the bailer has the right to terminate such a bailment or is entitled with the compensation for damages caused due to unauthorized use provided under section 153 to 154. Further, the next duty is not to mix the bailer goods with his own goods. It is the duty of the bailee not to mix the bailer good with his own goods. But if he want to do so, he shall seek the consent from the bailer for mixing the goods. If the bailer agrees for the mixing of the goods, then the interest in the mixed good shall be shared in proportion. While in case bailee without the consent of the bailer mixes the good with his own, then there arise the two situations. First, the goods can be separated, and second, the goods can't be separated. So in the first case, the bailee has to bear the cost of the separation, and the next situation, since there is a loss of the goods, therefore Therefore, the bailor shall be entitled with the damages of such laws provided under section 155 to section 157. Now, next duty is to return the goods on the fulfillment of the purpose. Bailee is the duty bound to return the good once the purpose is being achieved or on the expiry of the time period for which the goods were being bailed. But if the bailee makes the default while returning the goods on a particular time, then he will be responsible for the loss of the goods, if any, provided under section 160 to 161. Now, there was one case of Bank of India versus Grains and Gunny Agency. In that case, it was being held that if the goods are being lost or destroyed due to the negligence of the servant of bailee, then in such a case as well, the bailee shall be held liable. Now, last duty of the bailee is to deliver the bailor increase or profit, if any, on the goods bailed. Now, it is the duty of the bailee to return the goods along with the increase of profit subject to the contract of the goods. Further, we will be dealing with the rights of both the bailor and bailee. The first, we will be dealing with the rights of the bailor. Now, the rights of the bailor is equals to the duties of the bailee. So, it shall be the same. While rights of the bailee we can deal with, first is the right to recover the expenses, second, right to remuneration, third, right to recover compensation, fourth, right to lien, fifth, right to suit against the wrongdoer. After the goods have been bailed and any third party deprive the bailee of use of such goods, then the bailee or bailor can bring an action against the third party. It is provided under section 180. Thank you.